The Supreme Court on Tuesday struck down President Donald Trump's executive order seeking to end birthright citizenship, the guarantee of citizenship to virtually everyone born in the United States. In a decision by Chief Justice John Roberts in Trump v. Barbara, the justices agreed with the challengers, as well as all of the lower courts around the country that have considered the issue, that Trump's order cannot be reconciled with the 14th Amendment to the Constitution, which confers citizenship to anyone born in the United States and subject to the jurisdiction thereof. So Trump has been pushing back, and some of the Republican Party has been pushing back against the concept of birthright citizenship for the last couple of years now. This seems to be a fairly new thing. As far as legally, it has been considered since the inception of the 14th Amendment in the early 1900s, that as long as you are born on American soil, regardless of the legal status of your parents, that you are automatically an American citizen. And some people may argue that this creates perverse incentives. You know, somebody could come here illegally just to have a child, so that child could then be a U.S. citizen or whatever, but that isn't a terribly common practice, as well as the 14th Amendment is pretty clear. It's pretty succinct. It's pretty short amendment, right? And the wording is not very, they don't mince words, okay? It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that means that as long as you are born here, and whichever state you happen to be born in, you are an official citizen of that state of the United States as well. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Which basically means that as long as you are one of these citizens, as long as you are born here, you are considered a citizen, and these states cannot make their own rules saying, hey, we know what the amendment says, but if you're born to illegal parents or undocumented parents in our state, then you aren't eligible to be a state citizen, or you're not eligible to, the rules don't apply to you, right? They're not allowed to make a rule like that. If you're born in the United States, if you're born on U.S. territory, you're considered a U.S. citizen, period. Now, there are some other clauses to this amendment, but they aren't super significant to this. If legally it has been considered pretty clear for a long time, what would the dissent argue in this, right? Because it was a 6-3 decision. 3 of the Supreme Court justices voted for removing birthright citizenship and allowing Donald Trump to go ahead with his executive order, right? What was the executive order in question? Well, it provided that babies who are born in the United States to parents who are in this country either illegally or temporarily are not automatically entitled to citizenship. So it basically completely removed the whole point of it, right? The idea that regardless of your parents' citizenship status, you're immediately given and automatically given citizenship in the United States. It was trying to basically completely repeal the 14th Amendment, because that's kind of the whole point of it. Now, what is the dissent arguing in this? Because it's a 6-3 decision. So 3 of them obviously thought that this wasn't clear and that Trump was allowed to do this sort of thing. They made it a sort of a historical argument, I guess, right? The 14th Amendment was created in the wake of the 1857 Dred Scott v. Stanford decision, which basically held that, say you were brought here from Africa as part of the slave trade and you have children here, that those children were not eligible to be full citizens of the United States because their parents weren't, and that basically children of slaves were not eligible to be citizens of the United States of America. They were not automatically granted citizenship. The 14th Amendment was adopted in 1868, which was 11 years after the Dred Scott ruling. It was very much directly in response to that. Now, the dissenters in this ruling, the 3 that voted against or voted to allow Trump to go ahead with this executive order, essentially repealing the 14th Amendment, basically they were arguing that the legal understanding of what the 14th Amendment means has been incorrect for a long time. That it's not meant to mean anybody born on the United States soil or U.S. territory is automatically considered a U.S. citizen, but that this was a narrowly tailored thing that was only really meant to apply to slaves. If it's outside the context of freed slaves, then it doesn't really apply, which there really is no evidence of this, right? And what the justices have to go off of is the clear, narrow reading of the amendment itself. All they really are allowed to consider are supposed to consider, right? They can kind of do whatever they want, so allow doesn't make sense in this regard. But they're supposed to only really consider the clear wording of the amendment. And the amendment seems to be very clear in its wording that it's anybody born here is automatically granted U.S. citizenship. It's really scary that this was a 6-3 vote, that 3 of them were willing to completely throw out the very clear intention of the writers of this amendment to allow Daddy Trump to do whatever he wants, right? It also shouldn't be surprising at all that it's Thomas, Alito, and Kavanaugh are the three that voted for this, right? The three that seem to be the most sycophantic towards whatever the Trump administration wants. I think I saw a statistic just recently that only 5% of the time has Clarence Thomas voted against the Trump administration in cases brought forward to them, right? And they've also completely changed. I covered this. They changed the NCAN standard a year plus ago, that how they previously decided Supreme Court cases, like which ones were able to make their way all the way up to the Supreme Court. Because at any given time, there are hundreds of different cases that are appealed to the Supreme Court, but they can only take in so many per year, only a handful per year. But they've basically changed the rules so that they can allow the Trump administration to kind of like very quickly push their priorities and their cases through as fast as they want so that they can write new case law, because they have a supermajority on the Supreme Court at this point, so might as well take advantage of it and not wait until the perfect case gets to your desk, but just sort of pick and choose and allow them to bring cases forward to you. Sorry, it wasn't Kavanaugh, Thomas, and Alito that dissented. It was Thomas, Gorsuch, and Alito. Roberts rejected the government's argument that even if birthright citizenship was the norm in early U.S. history, by the time the 14th Amendment was enacted, the key question was whether a child owed primary allegiance to the United States, which in turn hinged on domicile, the place where someone has a permanent home. As an initial matter, Roberts said, there is scant evidence for this dramatically revisionist history. But in any event, he added, if Congress intended to limit American citizenship to the children of those domiciled in the United States, nothing in the succinct language of the Citizenship Clause conveyed that design. Citizenship then and now, Roberts concluded, was the right to have rights, to freely participate in our political community. The framers of the 14th Amendment extended that promise to every free-born person in this land. We keep that promise today. Justice Brett Kavanaugh agreed with the result that the court reached, that the president's executive order is invalid, but not its reasoning. In his view, Trump's order does not violate the 14th Amendment, but does violate a federal law providing that children who are born in the United States and subject to the jurisdiction thereof are U.S. citizens. Congress, Kavanaugh suggested, could amend the law or otherwise enact new legislation establishing exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in this country. But, he noted, Congress has not done yet. So I don't really understand this point here. He's basically arguing that, like, well, Congress could come out and amend the 14th Amendment, which of course they can. That is true. He says that law, like he said they suggested they could amend, which they can, but then he basically suggests that they could write a law saying like, doing exactly what Trump is trying to do here, that people born to undocumented non-U.S. citizens on U.S. territory are not automatically considered U.S. citizens, right? But that doesn't really make sense to me, because that would be in direct contradiction with the 14th Amendment, I would think. So I don't understand. I would assume that the amendment, the Constitution itself, takes precedent over the laws, and that's sort of what they're supposed to do. That's what judicial review is, right? They're supposed to review laws and ensure that they are not violating the Constitution itself, that they are constitutionally compliant. And so it doesn't really make sense to me that he would make this sort of argument, because I would think if Congress were to make this kind of a law, that it would make its way to the Supreme Court, and they should argue that, hey, this actually violates the 14th Amendment. You're not actually allowed to do this. I would think the only way that you were able to change this sort of a thing would be to amend the 14th Amendment of the Constitution, which requires a 2/3 vote in the Senate, which is not going to happen. Yeah, I don't really understand what argument he's making here. He's basically sort of siding with the reasoning of the dissenters, but disagreeing with their conclusion. And so theoretically, this sets up a scenario where really it could have been a 4-5 vote, and that if the Republicans are able to, conservatives are able to get one more Supreme Court seat, that it is possible that some sort of case comes forward at some point, or they manage to pass some law in Congress that allows them to remove 14th Amendment birthright protection. And so that's a pretty scary thought. It's pretty scary that it was this close. It's pretty clear what the creators of this amendment wanted. It's pretty clear the wording of the amendment, because if the people who wrote the amendment and voted for it or whatever wanted it to only apply to freed slaves, they would have made that very, very clear in the wording of it. But they didn't, and the wording of it seems to be open to anybody who's here is eligible to be a United States citizen as long as they're born on U.S. territory.